process. I was the third attorney on his file. His first attorney was too involved with CPS, was too involved emotionally, and felt that she couldn't go forward because she really disagreed with what they were doing, and she sits on the board with them here in Big Rapids. So she had recused herself. Carrie's second attorney ended up winning a seat on the bench here in Big Rapids, and so she, of course, had to come off the file, and that's how I came out of it. I bring that up because a lot of times when I'm contacted by a potential client and they tell me, you're my third attorney or fourth attorney, there's usually a bad reason why. And so, and it's usually when most people hear that, well, why did why he or she go through so many attorneys? And after talking to Carrie, that, those are very reasonable and very justifiable situation where I said, okay, maybe there's something to this file. So Carrie contacted me, and our first discussion, he told me what was going on, and I will tell you that I understand why CPS does what they do. I understand the laws, I understand the principles and the reasoning behind it. But I will, for all these years, I've been practicing for 18 years now in various areas. I have a general practice now, but I have always been involved with family law in one way or the other, as far as from pro bono with my family. I have 30-something cousins all down in Oakland County, Michigan, and I saw all of them had some sort of situation at one time or another to just helping indigent people to actually, taking on the files and being retained. I've been involved with against CPS in many files, and I do not agree with their tactics because I will be honest with you, in my opinion, my humble opinion, they are can be a very vicious group, a very vicious organization, and I will tell you that I always advise my clients initially to play nice first and see where that gets us, but always keep your guard up, okay? So when Carrie called me and told me about the file, I said, okay, I understand what's going on. There's a lot to it though. I'm way behind the 8 ball on this thing because there was 2 prior counsels on it, and they're already into it, almost a year by the time he had contacted me. And so we talked a little more, and I think we agreed at some point that we were a decent fit. I believed in him as far as what he was telling me. I didn't feel like one of those slime ball attorneys who says, oh, how can you represent these kind of people or stuff like that. I'm not, if I feel like a client is not being honest with me, or if I feel like we disagree, or if I can't sleep at night representing somebody, I'm not going to represent them. That doesn't necessarily attest to my clients, but that's just for my own well-being and my conscience. And I think obviously Carrie and I, he agreed with my tactics, my strategy, my abilities after we talked. So the purpose here tonight, when Carrie asked me to do this, was to give you an idea. Some people, his closest family and friends, because of the decision that came down that was adversarial to us, against us, his rights have been terminated. That I can't even imagine as a father. Well, I can only imagine, I should say. I have 3 little girls, and it was a very devastating decision, and one that I disagree with wholeheartedly. And I'll just tell you this up front straight. I wholeheartedly believe the judge got it wrong. And we'll go through some of those reasons why. But Carrie asked me to come and talk to some family and friends who perhaps have questions as to how could this happen, or perhaps you say, hey, did you do this, did you not do this, whatever your issues are. I've been more than happy to support Carrie in his personal endeavors as well as a professional in the courtroom and that. So I agreed to come and do this and talk to anybody who's willing to listen and to understand his plight, okay? So tonight, what I want to talk about, and we can, since we kind of have a small group here, smaller than what we expected, I'm more than happy to change directions depending on questions and what have you, but what I thought about tonight was just talking about how CPS works on the one hand, and then plugging in what happened in the case as we go along. Does that work for everybody? Okay. So when CPS gets a call into the central registry, somebody calls CPS and they have whatever issues, whatever complaint, anything from headlights to seeing a kid being dragged across a parking lot at Meyer X, to something very abusive, to mandatory reporters, that being doctors, counselors, teachers, and then if they hear something about a child being abused or neglected in some manner, they are mandatory reporters. They have no choice, no option, but they have to report that incident to CPS, to Central Registry. So you make a phone call, it goes to Central Registry then gets in contact, they'll make a decision whether to do anything or not do anything, and they will forward it to the powers to be in that county. In determining that, there's a two-step process based on these findings. The worker must classify into 5 categories when they go through this. Step 1. First step in this process is for the CPS worker to determine what level of evidence exists, whether or not the child has been abused or neglected. So they have to take into consideration from this phone call and decide right then and there, okay, the kid has life, do they do anything with it? Is it a 1-time call, 3-time call, 5 times call? They could decide right then that there's nothing to do and they could just shut it down, okay? If it's something more along the lines of abuse or neglect, then they take the next step and they actually start doing some investigation to find out how much evidence is there to prove abuse or neglect, okay? If they find, if there's no evidence of maltreatment present, the case is categorized as category 5, and the matter is closed. That just simply says there was a call to the complaint, and they put it in the category 5. There's 5 total. Step 2, if there is some evidence of maltreatment, the worker engages in the second step of the analysis, which is to conduct a risk assessment. What that does is that's if there's any, the level of that maltreatment, abuse or neglect, and then what it does from there is decide whether or not there's risk of future harm to the child. Okay, so then they'll put them into different categories. So what we have here is in November of 2013, November 1st, 2013, in this particular case, Carrie's children were transferred over to his ex-wife, okay, sometime around 7 p.m., okay? That night, Amanda is the youngest daughter, goes to the bathroom and complains of blood. She sees blood in her urine. So she complains to Mom. Mom then goes there and decides she's going to take her to the hospital. So they take her to the hospital. They get to the hospital around 9. They transfer them over to Grand Rapids, and they do a beginning examination, initial examination assessment, and decide then that they're going, as mandatory reporters, they notice that there is a tear in the cracked area. Okay? Nobody can state what the tear is from. They don't know if it's from her head slipping and falling. They don't know if it's from her wiping too hard. They don't know. Nobody can attest to that. They ask her. She says, I have no idea. They call a specialist out of Grand Rapids, Dr. Sims. Dr. Sims comes to the hospital. They do a rape kit investigation on the little girl. The rape kit investigation comes out negative. There are no findings whatsoever of any type of rape or anything, okay? Dr. Sims comes and wakes up the little girl at roughly between 5 and 6 a.m. in the morning, okay, while they've been there the whole night now. Wakes her up and she's barely awake and starts asking her a bunch of questions. At this time she's 4 years old, 5 o'clock in the morning, hardly been sleeping, staying in a hospital. And she says, do you remember what happened to you, how this happened? And the little girl says, I don't know. Okay? Dr. Sims, despite there being no physical evidence, okay, of any type of harm coming to this little girl, in her opinion, because she can't remember how this happened, then it must be a sexual assault. That's what kicks this whole case off. The little girl says, I don't know how this happened. And the doctor says, in all my years of experience, when a child says this, that must be a sexual assault. Okay? So as a mandatory reporter, they report it to CPS. CPS gets it in Central. They do step 1. Obviously, there's some level of evidence. There's physical evidence. They now have a doctor, expert opinion saying, must be sexual assault. That's the conclusion at that point. Okay? Nobody thinks to grab the underwear to see how much blood. Nobody thinks to ask any other questions in detail. Where were you all day? Who were you playing with? Who were you with? Who were you around? Who was with you? Nobody asked those questions. But yet, nevertheless, because she can't remember, that was her opinion. So subsequently, Mr. Flagg calls because he finds out that the kids have been left alone with other children sometime in this time frame. And so there's a negligent supervision issue, as well as with some kids who have a past history of some sort of, I don't want to say, well, sexual acting out. I won't say abuse, I won't say anything like that, but sexual acting out. There is testimony subsequently that was found out that these kids would do, they rub their crotches together. And whether they were clothed or naked, that's what they were doing. So the idea, you can infer that there's perhaps some other things going on. Toys being inserted, things like that, okay? This comes out later in forensic interviews, but nevertheless, Mr. Flagg calls Central Registry and says, hey, this is what I was told. They go out 2 days later, November 3rd, and do an investigation, or talk to Mom. Mom says initially, no. Kids have never been left alone. Right? They say, okay, well that's weird. Let's go figure out what's going on then. She calls back. I can't recall off the top of my head. I apologize if it's days later or hours later or what have you, and says, I lied. They were left alone, but I only left them alone for 20 minutes. And so what a common theme that I found in this thing was that there are people here, and this is why it makes me very suspicious. To me, is a huge tell when somebody's actually lying more than they want to tell, is they tell you half-truths. You ever get that? And it's just enough to be believable, isn't it? You're like, well, no, I didn't drink all of the milk, Dad. I took a couple sips. Well, that's weird, okay. Well, then who drank it? You know? Well, that would explain why your daughter, the cup, that would explain everything, because she only had a couple sips, but truth of the matter is, she finished it and still put the empty container in the fridge, right? But the half-truth makes you go, oh, I wonder who else in this house did it. So throughout this case, that's what we seem to get. We get little half-truths. And the problem with that is CPS took that as the gospel. They took that as, this must be what's going on. And if you look at it, and you can even say Dr. Sims is the same way. She got a half-truth. She got here's my injury, half-truth. How does that happen? I don't know. So she takes the rest of it and says, well, something bad must have happened. You see? Okay, so CPS, and then I'll just finish off the other categories. So there's categories, 4 is when community services recommended. There'd still be no type of petition by the courts to intervene. The investigation determines that there's some, but less than a preponderance of the evidence of abuse and neglect, and the risk assessment indicates that there is a future risk of harm to the child. In this case, CPS would assist the family in community services, things like that. Category 3, community services needed. There's a preponderance of evidence that abuse and neglect took place, and the risk assessment demonstrates a low or moderate risk of future harm to the child. CPS must assist the family in obtaining services that are commensurate with the risk to the child. However, if the family does not participate in service or does not benefit from services, DHS must consider reclassifying the case as category 2. For those of you who have run into somebody with CPS, this is where it gets tricky. Category 4 is just above closing out the file. Category 4 says, yeah, all right, there's some issues, but we're not really going to do anything. We make some suggestions. You take it or leave it, Mom or Dad, right? Boom, done. Category 3 says, we've got some problems here. You need to volunteer for these services we're recommending. Now, it's a tricky word, volunteering, in this thing. If you don't volunteer, CPS will seriously consider or even threaten, or will just simply do it, file the petition, and it kicks it up to a category 2. Category 2 is where the court will intervene in your life. Not necessarily for termination, but they will intervene to make sure that you do what you're doing in the best interest of protecting the child. So again, I get it. I get what the purpose is of DHS and CPS is, 100%. But it's the method and the way the statute's written that I have problems with. Now, obviously, as we go through this a little bit more, you understand my beliefs of why there's problems with the application of it. Because category 3 says, You have to volunteer, or else we're going to file a petition with the court. So is that really voluntary? Are you doing that? And then category 1 is, of course, the petition. The court is required to investigate the results and preponderance of the evidence that maltreatment occurred and that one of the following is also true. This is category 1. The harm to the child requires a petition be filed with the court. The child is not safe in the home. The case was categorized as a category 2 case and the family did not cooperate with the required services. There is a felony assault or child abuse in the first or second degree. When the case is categorized as falling into category 1, DHS must petition a court, open a CPS case, provide services to child and family, and list the perpetrator in the central registry. So this case here, because of what I just told you about in the beginning there, immediately went into category 1. Okay? What they did was they started investigating a little bit further. They had what they called a forensic interview, and they used the guise, under the guise that, hey, we're going to do a forensic interview with the children because of Mr. Flagg's call about the negligent supervision. And in that negligent supervision, we found that Amanda wasn't there. So we're going to find out what really happened. That's what they claimed, right? So they set up a forensic interview with the children at CPS headquarters here in Big Rapids. And they have a police officer there. Okay? A police officer for Amanda's not being there for her kids for what she claimed was 20 minutes? That doesn't pass the smell test for me. I call BS. This whole forensic interview was a setup, Mr. Flagg. It was a setup because at that point, in her mind, when the kids were at the hospital, it was to get Carrie. She thought he had done something, and the whole purpose was to get these kids to admit that they had something had happened to them, and Carrie was the perpetrator of it. Okay? So they go to the forensic interview, and when you have a forensic interview done, the state of Michigan has a suggestion and recommendations of the protocols of how forensic interviews are supposed to be done. For instance, and because the purpose of them is to get a child to tell you the truth, to be honest, not to be intimidated and tell you what they think the adult wants to know, not to be silly and be imaginative and create things, but to tell you the truth. And so they created these protocols, and they worked with this committee for a number of years with lawyers, judges, psychologists, child psychologists, in human behavioral science, and put these protocols together. And to give you an idea, some of them are, you don't ask the same question over and over and over of a child. You ever do that with a grandkid or your son when they're kids? You ask the same question over and over, and they say no. Did you pick up the toys? And they says yes, and you're looking at the playroom, and obviously there's toys on the ground. You say, did you pick up your toys? At some point they're going to sit there and say, well, my dad does not like my answer, so I'm going to change it. That inevitably is what children do. They're looking for approval, they're looking for affirmation, and the fact that you keep asking them is very puzzling to them. Okay? The forensic interviewer in this, asked 9 times of a 4-year-old little girl, did you touch your dad's penis? In one way or another, asked 9 times. And the little girl, 9 times, said no. Okay? Huge violation. Another protocol is not to have a police officer in uniform in full view of the child. Because now you have an authoritative figure, right? And the child thinks, I'm in trouble. So if you don't like my questions, my answers, if you don't like my answers, right, I'm going to be in trouble. So I need to satisfy you. And that's the general idea behind it. Well, so the officer was there. The children, each one, when they come in, ask about the police officer. And he's in plain view. He has his badge, he has his gun, he has his uniform, and he's standing there while the interview is being conducted of these little kids. Okay? Another violation of the suggested protocols. These aren't laws, they're suggested protocol of how things are supposed So, they go forward, and when the interviewer is not happy with the answers of no, what the interviewer does then is say, well, can you draw a picture of your dad's penis? And there's a response in there, and I will tell you that as many times as I've heard the audio, it's a penis. The little girl responds with a penis, not my dad's penis, a penis. Okay? And so she draws a rectile picture. And the interviewer says, is that your dad's penis? And she says, a penis. Never says, yes, that's my dad's. It says a penis. But in the interviewer's head, boom, that's it. Okay? The interviewer also asks about pants being up or down, because this whole thing took this direction of wrestling around in the living room. And Dad had sweatpants on, and the little one pulled his pants down while they were wrestling. Intentionally, unintentionally, never asked. Interviewer says, what did you see? I saw he has a hairy butt. Never penis, hairy butt. Child also says, she said, what, have you ever seen other private parts? Again, this is the language also suggested by the interviewer, not by the child. The child says, I've seen my mommy's private parts. Says it's hairy in the front. The interviewer never followed up on it. Never asked, why did you see your mother's private parts? Or whose other private parts have you seen? Nothing like that was ever followed up on. It was simply focused in on what my opinion was, Carrie Flagg. She ignored all that. So, as you go through the forensic interview, what you also find out that you can't do in the protocols is actually leading questions. Right? You can't say, well, you were there on Thursday, weren't you? That's not how it works. It's open-ended questions. But what the interviewer does, as it gets towards the end of the interview with this child, with the youngest one, is she tells her the time, location, and time and location, and the events that occurred just before that, inside the home, when she claims this incident occurred. The interviewer does. She says, oh, this happened in the bedroom, didn't it? Oh, this happened after you guys watched movies at Daddy's house, didn't it? Never did the child admit. She said, I don't know what you're talking about. The child never said, this is going to happen, this is what happened. But the interviewer took everything that she feels that she had put together and said, this child admitted all these things. When she drew a picture of a penis, they took that as dad's penis, although never admitted to. Although it's also stated that she had never seen it. So at the end of the cross-examination of this interviewer at trial, she admitted she could have handled this whole thing a lot better. After pointing out this, amongst other errors. Okay? As we also went through the forensic interview, we also learned that the other kids had admitted that there was some sexual acting out with other children. It was typically the three older kids, but now you have to remember, we had four kids, and these other kids that were over, that were unsupervised. So the little kids, we don't know what may or may not have happened. There is some testimony subsequently, not in the forensic interview, that there was a recording so the kids were present, the younger ones were present at some point. But there's an admission of sexual acting out on the children, but it's never followed up on. And get this, at trial, CPS caseworkers said on the stand, they do not investigate child-on-child sexual behavior.
So it could be a 12-year-old and a 2-year-old.
That's right. You're absolutely right. And because that was my question, why didn't you follow up on this? And that was the response was, they don't investigate me, because I wanted to know why they didn't follow up on these other children who were at the home where this could have occurred. Because nobody got a timeline as far as when these acts may have happened and during the unsupervised. And now their claim is that the acts, the unsupervised acts, the sexual acting out, happened way before this November date. But although we have an admission that they were unsupervised at that time. So they had already predetermined when that had happened and that nothing had occurred, and they took her half-truth of 20 minutes as the gospel. Okay? So the forensic interview, they do all the children. There are a number of other kids, 12 years old, 11 years old, other kids that come up in the interview, the name, and they're never followed up on. When you can read and you can hear it in the audio, because we haven't transcribed, when they start bringing up these other kids, they want the younger ones want to end the interview. And instead of following up on these things or having a subsequent forensic interview on different topics, because you don't want to have too many forensic interviews because you start getting the repetitiveness and the child thinks you want these different answers. But instead of following up on these different topics, these different kids, they don't do that. But when the children are asked about these other possible alternatives, they want to end the interview when it comes about these other kids. And CPS, instead of following up, says, okay, that's fine, we'll end the interview. So again, here's all these dangling possibilities that are never followed up on. So the kids are interviewed, Mr. Flagg is interviewed. Okay? He's like, I have no idea what the heck is going on, is the basic premise. He's like, I don't know how this could have happened. Okay? The mother is never interviewed. There's a discussion with her, but it's not recorded. There's never any forensic interview with her. Despite the fact they already have an admission of a lie.
How can this, it baffles me, all right?
Mm-hmm.
Common sense, I mean, how can the hell can this, excuse me, that happen?
Yes?
I don't understand it. I saw her in the store today and I wanted to go up and grab her and kick her in the crotch and throw her on the ground.
Well, I would.
And I didn't.
Well,
And I was afraid to go talk to the girls,
Yeah.
even though they saw me.
Yeah. Well, I appreciate you restraining yourself, because if you're not going to, I'll give you a card before you leave.
I'm not going to, something I'm going to do.
Okay, but here, let me tell you my general theory of what happened, okay? I honestly think when she left those kids alone, something happened, right?
Probably from the nutty trouble.
Just listen. So I think something happened. I think the little one may have gotten injured in some manner, obviously, because we do have a physical problem. We do have physical evidence of a problem here that needs to be figured out. Well, I think something happened while she was gone. I don't think she was gone for just 20 minutes. I think she was gone for longer than 20 minutes, even an hour. Okay, and we already have past history of these children who've shown that when they are by themselves with other children, they're sexually acting out. So I think something happened, okay? And I think when she saw the bleeding and all this, she panicked and thought, I had to take my child to the hospital. Something's going on. She's hurt. I think when she went to the hospital, I think she thought she was going to be in trouble. I think she's the one who was panic-stricken because that's why she lied about not supervising them, about leaving them alone. But when they turned this whole thing and focused on him, I think she glommed onto him.
Right.
She said, I have a free ride. That's my theory.
That's what
I think it fits too perfectly that's because to say how this thing went down, in my humble opinion, it doesn't make sense.
No, not a bit of sense.
You know?
Carrie and I go back and we work together, yeah, there's,
I don't know,
I
but
don't
so much
understand.
of
It's
the
so
law.
angry because the law is supposed to protect people.
Well,
And in
the-
this case, they're not
Right.
protecting him.
right, and that's why I said I agree with the principle of the law, but in its application is where we run into some difficulty, and we'll talk about that a little bit more as we go. But in this scenario, I don't know wholeheartedly if she actually had a split, what Dr. Gordon called that? Saddle injury, yeah, a saddle type injury. And because he brought in, Dr. Gurdon was our expert regarding the physical evidence, was that there was a straddle injury to the logo, which can cause this very accident. And he brought in specific examples of it. when they don't recall is actually why it's a strangletype injury, because there wasn't a lot of blood, and he found a satellite bruise in the crotch area to the side, which to him indicated when a little girl falls, which Dr. Sims had never identified in any of her reports. And I will tell you, at court, they never responded or rebutted our evidence of a satellite bruise. Dr. Sims never came back in the courtroom and said that is or isn't a satellite bruise in her opinion. But in the photos, you could see, once Dr. Gert pointed it out, there was a bruise. There was a discoloration there.
So why would she call back to me to testify to that?
That's not. I'm glad she did. It's the prosecutor's responsibility to make her answer. The fact that they didn't adds credence to our. We put up testimony that says there's a bruise here that you guys missed, and they ignored it. That's on them. And that's again why the decision seems a bit confusing, because in the judge's opinion, he ignored Dr. Gurton 100%.
Yeah, but she took her right to the hospital and saw that. Wouldn't there have been other evidence? If there have been, and of course, wouldn't there have been other evidence, like the semen, other evidence?
Right, they did a rape kit. They did a rape kit, and there was nothing.
Yeah,
Yeah, they did a rape kit, and it came back zero. Nothing. Okay.
How accurate is a rape kit? I mean, like, what if it was like, I know Carrie's innocent, but, what if it was like 8 or 12 hours earlier?
Yeah, well, they do the swabbing, they try and find DNA, and the only thing that obviously comes out of it is the tear. That's the only thing that all the evidence is. If you're asking how accurate,
Yeah.
I'm sure that rape kits have missed things in the past, but at the same time, there's no way to know that for certain. But it searches for DNA, it searches for other
So it's fairly
chemicals.
thorough.
It is.
To an extent.
It's for it to miss. If something happened, for it to miss is kind of surprising.
Okay.
Okay, so along, like I said, I'll go along the lines of CPS investigations and that. So we have that. They then decide to set up a polygraph test. I'm going to tell you as an attorney, regardless of if it's CPS, criminal, for fun, whatever somebody asks you to do one, don't. Don't ever do a polygraph test. There is a reason they're not allowed in court. A polygraph test is not allowed in court because they're simply unreliable. But more specifically, if the authorities ask you to do one, it's a bad idea. And the reason is because they can sway how it occurs. It's not about the truth. It's about how nervous you get. You ever answer a question, you tell them the truth, you're like, oh my gosh, well, I'm telling you the truth, but why am I so nervous? I'm sweating bullets and you're sitting here asking me these questions and not being honest. That would come up as deceptive. It can very easily, okay? And here's the thing about the authorities. When state troopers or police, when they do a polygraph test, more times than not, they will mess with you. And it's intentional. And what you should have in a polygraph test is an extremely calm area. Nothing to make you nervous, nothing to sway you one way or the other. I've had clients who come and they've asked for polygraphs, and I've had clients insist they want to do it, so I've gone with them, okay? And we go to a place, and guess what? It's at a police station. Well, you're nervous right there. Ton of police cars out front, ton of police officers in there. He was being accused of something with his children and that, and they literally, I kid you not, I said, this can't be coincidence. They had 2 little kids playing out in the lobby who just happened to show up there with this woman. Nothing to do. They didn't go in and check in because I was like, well, if they're checking in, I can see that, I'm looking for John Smith, blah, blah, blah. Okay, we'll wait out here. They didn't check in. They were just standing in that area playing. Boy, that's peculiar. Yeah, it was an absolute setup. I talked to the prosecutors later, and turns out they absolutely did that on purpose to see if they could make them nervous. Okay? So, don't ever do them. And in this scenario, they had CPS, and what they do is they establish a baseline of your behavior. This is where a polygrapher will tell you that, no, they're pretty accurate, I'm pretty good. Because what they do is they establish a baseline. So if you're nervous and yelling, then they'll turn around and say, okay, that's their baseline, they're just nervous. So if you get a little more nervous, deceptive, right? But once they establish a baseline, the other trickery they do is before they record anything, they may throw something in front of you or ask you a question that's left field. you're starting, your baseline that they said was here, it's actually up here. In this scenario, they asked Mr. Flagg, after establishing a baseline, if he knew that his daughter drew a picture of his penis. 1, not true. Didn't draw such a picture. She drew a picture of a penis. 2, they did it after they established a baseline. 3, CPS workers were there at this interview. So Mr. Flagg failed. Okay? So they climb on to that and say, oh my gosh, he failed, so he must have done something. I had Carrie do a polygraph for me, for a gentleman who I had never worked with before. So, because sometimes, you know, we have experts we go to, you know, they tend to favor us, but it's not like the states, man. I mean, that's their business. They're doctors, they're polygraphers, all that. That's what they do, that's their bread and butter. And some lawyers have that. I don't. I try and find somebody in the area, ton of experience. Never worked with this guy before. Carrie went and met with him. Picture on the wall, plain white room, table, 2 chairs, and a machine. That's it. Just Flagg pass. I waved that thing around. Okay, I waited for the right opportunity. And when I said he passed, you should see the prosecutor's face and guardian ad litem. There's like, not a word. They wanted a copy of it. I said, absolutely. The only thing the polygrapher and I talked about were the questions that should be asked. And I said, I'd like him to match as much as possible what was asked of him in the other polygraph test, and perhaps some other ones about this. Oh, and let me go back real quick about the picture that was drawn. At trial, it was brought up that the youngest one, a month later, after the forensic interview, the mother called in and said, my daughter drew a picture of a little boy peeing, and she drew a picture of his penis as well. So I'm really worried. In the notes from CPS, you don't need to worry about that. Girls of her age should have basic knowledge about those type of things. And her drawing a picture of a little boy's penis is not an indication of sexual assault or anything. Right. So I went after this while they were on the stand. Said, so how is this picture okay, but this one, where she says a penis, but you kept saying dad's penis, they're really not different, are they? She just drew a picture of a penis. So now we have an explanation as to why this picture exists, right? Because some people are like, well, how can this picture exist? If this little girl, well, according to CPS, it's perfectly normal. Right? So now he passed the polygraph test as well. But I will tell you, had he been my client at that time, I said, don't you dare take it. I don't care. I have my clients who take one privately, and if my client fails, I do throw it in the trash, because it still means nothing. If he passes, I can throw it in the trash also, because ultimately it still means nothing. Right? But I will tell you, when they pass this, I hang on to it, because if they say, well, your client's lying, we have a polygraph test, I say, well, so do I. You know, so it means nothing.
No, that never gets mentioned either.
Right. But what they did was, and this surprised me, is they allowed, polygraph tests aren't allowed in court, but they allow the interviewer to testify and to give his opinion about them telling the truth. He, of course, says that in his opinion, Carrie is lying. And other statements he made are contrary to actually his notes, which we're taking those issues, those are other issues we're taking up on appeal as well. Our polygraph guy comes in, testifies in all his years of experience. He's been with the state police 30, 40 years. Carrie's telling the truth. But for whatever reason, in the opinion, the judge ignored our guy and glommed on to the state's guy.
If I can, and I'm not trying to interrupt.
No, you're
I
fine.
actually have the picture, and it's nothing disturbing. That is a copy of the picture. You can see the stick figure in circles, and then that arrow over here is actually supposed to represent what they consider dad's penis.
This is the one that you drew at
At the forensic interview.
Oh.
That's the one I see, yeah, I just looked that over. Proverbial screaming at the screen and saying, what the?
Yeah.
Mm-hmm. Yeah.
Okay, so some procedural stuff then. So what happens then is, once they find that there's evidence of some sort of abuse or maltreatment going on, CPS has the right, as does any doctor, any police officer, to remove the children from the home legally and physically as well. But since they're staying with mom, they could legally remove them from Carrie and sort of suspend his parental rights, so to speak. In doing that, they have to have a hearing within 24 hours. So we have a procedural problem here because in this case, that is supposed to be heard by either a referee or a judge. And it's supposed to be done within 24 hours. Mr. Flagg, and now again, please remind you that I was not involved in the beginning, my understanding was not given notice of any type of hearing within 24 hours, despite CPS to the contrary claiming that they did give him notice, but it supposedly happened on the same day. Then the order is signed, but the order isn't signed by a referee or a judge. Signed by a clerk in the courthouse. It's not legal. The order is not. The order is not legal. So, right, but now, and I will tell you the due process problem is that, again, this happened prior to me being involved. Other hearings do occur subsequently to that, so I will tell you most likely the Court of Appeals would say, well, despite the violation of due process at the 24-hour mark, the fact that he did eventually have his hearing makes up for the due process violation. Okay? Right, but it gives you an idea of like a head scratch, like what's going on in this scenario? Yeah, I didn't want to say county, but yeah, what's going on in this scenario, right?
So the judge ruled that way because CPS had it wrong and he didn't want to get in trouble?
I can only speculate why the judge ruled that way. I can tell you this wholeheartedly. The burden of proof is clear and convincing. And I've done not quite like this format, but I've had this discussion in Mr. Flagg's case with a number of colleagues, CPS supervisors that I'm familiar with or associated with. And I've tried to be as objective as possible. I'm not taking this thing. I'm telling you that the truth, as straightforward as I can be, that I get it. I understand why they intervened. I do. But how come they didn't do these certain things? I don't know. And I can only tell you that I don't, this thing is not clear and convincing to anybody I've talked to. And I believe that the other side of the prosecutor's office, if he would tell me the truth, I bet he'd be surprised by that decision too. In all honesty. Because they asked for written briefs for closing arguments, as opposed to just doing oral closing arguments, which he's never done before. So I got a sense that he was waiting to appeal the decision that would be in the format. Again, I'm speculating, I don't know, but if I were betting man, I would bet on that. But I also would bet on that we won the case. The way this went. I mean, there were certain things that we had to disprove. We had to explain. We had to explain the injury. We had to explain the forensic interview. We had to explain the drawing. And then there's one more that we talked about. The second oldest child made some remarks in front of the doctor.
Youngest.
Oh, I'm sorry, youngest, yes, I got back. Yeah, the youngest child made some remarks in front of the doctor that we had to explain. And those remarks were, please touch me the way Daddy does. I want my daddy, these outrageous, inexplicable, unexplainable statements by the youngest child. And it hurt us because how do you explain this? But then you start looking at the timeline. During the forensic interview, which happened immediately after these accusations were made, there is no such statement from this little kid. Okay? All right, well that's peculiar. No such statement anytime ever in school. No such statement ever to any doctors. No such complaints by any other parent, by any other party involved, by CPS before that, by teachers, counselors, nothing, right? This all starts falling apart. And this is why I tell you, this is part of my theory, why Mom, I think, glommed onto this thing. Goes to see, gets a risk assessment done. The judge orders risk assessment by a doctor to say, well, are the children at risk? Okay? So he goes to do this interview. guess what the youngest one says now? After she's been removed from dad and is only having supervised visits with dad for 1 hour?
1 hour. But before this, I hadn't seen her for over a month.
Right. After she hadn't seen him for a month, but only had 1 hour visitations once a week?
Twice a week.
Twice a week, so 2 hours a week, that's all he gets to see. Gets to see dad, and it's been over a month. Goes to see the doctor, now makes all these outrageous statements, and the doctor himself says, it was the craziest thing, I wish I re-recorded it. Well, okay, one, why didn't you? But fine that you didn't, you don't have to. But it's so outrageous, you didn't think that was peculiar? I mean, he's done thousands of these. And this doesn't strike you as odd? And so I asked him about coaching, and he says there's no way this kid was coached. There's no way this kid was coached. Do you know what his report says on the front page for the assessment for this child? That the child was overheard telling mom, if you don't buy me ice cream, I'm not going to do what you ask.
There you go.
But that's my argument. Yes, sir. I believe
I've always
wholeheartedly.
said that.
I believe the wholeheartedly.
The carrot is.
But he denies it. He says in his opinion she wasn't coaching. He says you can't coach this type of behavior. Right? I
I'm
believe she,
so afraid of the mother that they'll do anything. I think she's.
or not even afraid. I mean, just offer your kid ice cream and see what you can get him to do. I get my kids to do just about anything. If I say I'm going to take away your Halloween candy unless you do this, guess what? They're doing it.
She's freaking nuts.
Okay? The child also makes the statement on a home visit months later after I hadn't even seen Mr. Flagg, after his parental rights have been, his visitations have been suspended, not even supervised. She goes to the home to do a home visit, and the child, oh, I wish my daddy were here to rip off the clothes on himself. That's it. Again, outrageous behavior, but never reported except for what? When the governmental authorities are there? That doesn't seem peculiar to anybody? And they were okay with it. And again, and they had a plan for the mother that she was not to leave the kids alone with those other kids. We had established that she had ignored that safety plan, as they called it. She had ignored that. She had even lied to them about where they were sleeping. Because they were sleeping in the living room floor on mattresses together. But it's all disregarded. It's all ignored.
I don't understand how they can do that. Just be able to handle it.
Mine as well. So in the process, what happens is, after the 24-hour hearing, that may or may not have occurred, they don't have any record of it. They just have a signed order that something happened by a clerk who, not a referee, not a judge. There is supposed to be what's called an adjudication hearing. And this one you get to have by jury. And what it is, it's the petition gets filed, and you get to have a jury of your peers decide whether or not the state can intervene in your life. I will tell you, as an attorney, if you're facing this situation, you press for that hearing no matter what. Okay? Because typically what happens, especially with clients, people who get court-appointed attorneys or get bad advice, is they will say, all right, well, I will plead to something in the petition and allow the state to take jurisdiction. You just allowed the state into your life. Now, they're already in it because of the 24-hour hearing, but you have to establish the parameters. This is your time to control it, or at least attempt to control it. So you should have this hearing, don't ever waive it, don't ever plead. If you plead, okay, what you plead to can be used against you later. So if they go to move for termination and you already took a plea at the adjudication, guess what? What you admitted to is admitted to at the end. And you can be terminated. Even if the initial petition doesn't have termination on the table. If it comes subsequently, they can use that plea against you in the termination. So don't ever plead. If you do plead to something that's innocent. I will tell you, I had one in one county, and prosecutor kept pressing for me to plead. I told him, kiss off, we're not pleading, we're taking this to the adjudication trial. And they finally agreed to put something on there that said that the water heater, that she was ignorant of the water heater temperature. That was it. Which they were gonna hit us on anyways. But nothing about abuse, nothing about anything else. Because then I could also turn around and say, and show that she had receipts and everything, that she had the water heater checked out and adjusted accordingly to what happened. The child had suffered burns in the bathing incident. So we decided to go with that, and they would move for termination. Guess what the prosecutor tried to do? Use that plea for termination. I said, Your Honor, that's proof of nothing. So she didn't know what the temperature was. That's negligent at best. That's not intentional. That's not, and it doesn't continue on as a future harm. The judge just looked up and said, yeah, get out of here with that, right? So we ended up winning the termination, okay? But nevertheless, but that's how dangerous that can be. So if you know somebody, or if you are involved, what have you, don't plead to something that's going to affect you at the end. Whatever you do, they're going to bring it up at the end, okay? So you get a jury trial for adjudication. It's by preponderance as to whether or not those elements we talked about previously are involved, and if they are, then the state is allowed to intervene in your life. This is also the opportunity for your lawyer, who needs to do their job way before that hearing, to nail them on their testimony of what they got now. That's another reason why you push for this hearing, okay? Don't wait for it later. Every hearing, question them, push them, shove them around. Show them that you're not there just to be shoved around yourself. Show them, hey, I'm not being defensive. You're offending me and I'm gonna go after you. Why are you in my life? Why are you here? Okay, every time I've had these 24-hour hearings, and I've had these preliminary hearings, and I've had these adjudication hearings, I go after, I don't have any friends in CPS, I will tell you, in various counties in the state. And it's because they don't like being questioned. Do you know why? Because these are young kids who just got out of college. They're getting paid $30-something thousand. They'll be in the system for about 5 years. They max out at $40-something thousand. They go through 9 weeks of trainings. They're not married, don't have kids, typically. They have no clue what it's like to be a parent. They think a little kid rubbing their crotch on the floor is somehow some sort of sexual indication of something sexual going on. And think about that for a moment. If I tell you that, and Carrie and I were talking about it, if I tell you that, you know, my teenage son, or I know a teenage boy who masturbates. Right? Not a big deal. Kids do that. People do that, right? But if I say he masturbates and his dad is being charged or allegedly has some sexual assault pending against him, changes the content of it, doesn't it? The context. That's what happened here. And the next step, what I was going to tell you about was the judge then orders these assessments, risk assessments and psych evals to happen with doctors. These are state doctors. Majority of their work, majority of their income, well into the 6 figures, is premised upon these evaluations from the state, from the county, okay? And so, and the one that testified, in this case, against Mr. Flagg, he admitted he's done thousands of these. Right? It's his source of income. What also happens though is when they get these referrals, they don't get a phone call from Mr. Flagg. They don't get a, hey, can you talk to these kids at this time frame and go forward with this? They get a phone call from CPS and some files that says, this is what's going on. Dr. Sims told us that the sexual assault occurred by the father. Or she actually doesn't say who. Dr. Sims says Dr. Sims says sexual assault occurred. Our forensic interviewer says that the little girl drew a picture of the penis and says that she has seen dad's penis. Okay? That's what he gets. Oh, and by the way, he also failed a polygraph test. That's what they get. So now you say this little kid's sexually acting out, and then you put it in the context of what they believe, which, as I'm telling you, the evidence shows is a farce. But they get all this as the background. Guess what his opinion's going to be?
It's tainted.
Yeah, it is. It's absolutely tainted. But somehow, some way, they're okay with it. Now, we go forward with our experts, and they get criticized because they only have interviews with Mr. Flagg. But yet, and we get criticized criticized because it's Mr. Flagg's side of the story. That's the opinion that came down against us. And it's one, again, where you have to scratch your head and you're like, really? Because all throughout the transcripts and trial, each one of these doctors is telling you, yes, I got this report from CPS. Yes, they told me this, A, B, C, D, and E. Okay? And in every one of the reports, even though it's not allowed in court, they all told the doctors that he failed the polygraph test. And the doctor put it in the reports. Okay, so you have the adjudication, the jury trial. At that point, they decide whether or not to intervene in your life. The jury makes that decision. Now, I will tell you that in this scenario, they did an end around on Mr. Flagg by going after Amanda for the November 3rd negligent supervision, not being there incident. She pled, saying, yep, I was negligently supervising the kids, I wasn't there. So that gave the court jurisdiction to intervene. And usually when they do that, if the kids are in danger, they remove the kids from the home, but guess what? The kids are given back to Amanda. Status quo. So despite the fact that they felt there's grounds to intervene because she was a bad parent for that incident, the kids were returned to her immediately. And again, I believe this was an end around on Mr. Flagg's rights. Because had they not, he would have had more time with the kids. There's other things that could have been done legally, counselors, things along those lines, more of a fight. But since they're now removed, they can intervene. It affected his rights. Subsequently, 4 weeks later, 11 days later, when you have a report from CPS, you're put on what's called a central registry. So it's kind of like this report card, from CPS, DHS, so they can check it and see how many times they've had run-ins with you, how bad of a parent you've been, or whatever the case might be. You get your name removed off of that. It's kind of a pain in the butt. You have to petition for it. You got to get CPS to agree to it, blah, 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 all this stuff, right? 11 days later, after they took jurisdiction on Amanda, they removed her off central registry. 11 days. I hardly know the woman, but she didn't strike me as somebody who was going to be that ambitious and motivated to petition that out on her own. Somebody else is behind that, wholeheartedly. So they had the trial with Carrie, and guess what? They find out that the forensic interview was recorded, but they don't tell his attorney until the day before the hearing. It's a 2.5-hour interview. So they give it to her the day before. She asks for an adjournment. They say, no, that's what good lawyers are supposed to do. And so she has to spend her time getting that. And I will tell you, it helps when you hear an audio, especially for 2 hours, 2+ hours like that, it helps to have it transcribed. Thank you very much, by the way. Sarah did the transcription for us, saving a few bucks here and there. But it helps because as you're reading it, again, you can count. As opposed to going, go back. But when you have it there in front of you, it is killer in the courtroom. Okay, as opposed to trying to recall things. And so his attorney, unfortunately, had to go in that courtroom and go off memory and just didn't have it all laid out. Okay, for whatever reason, that's just how it went down, but the judge still went ahead with it. Again, I think procedurally that's a problem because the forensic interview is one of the first things they rely on. The doctor had an opinion that something had happened, and then the forensic interview supposedly backed that up somehow, even though that was, to me, was a pretext to go after Mr. Flagg. But that's what gave it some backup, because Dr. Sims said, I don't know who did it, but I just believe that somebody did something to this little girl. Then here's the forensic interview, says, oh, this little girl says she's seen dad's penis. Okay? But so to me, this was a huge problem. So they go forward with it, by a preponderance, the jury finds barely that the court is allowed to interview. And so it's a petition for termination, so now begins after that, all the legal wrangling for the trial of termination. So we go to trial, we have our polygraph guy, we have our medical doctor for the physical injuries, we have our psych guy, our psychiatrist, with regards to their assessments and all that, and we counter everything, and then 2 days, 3 days before trial, I get a stack of papers like this that they've had, CPS has had for months, and their counseling records from the kids. I object to them being entered. The judge says,